Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. We have heard learned counsel for the parties and perused the record. Learned counsel for the petitioner could not show that in law he was rightly paid by the respondents and he was entitled for payment of salary in the manner it was fixed with effect from 1/7/1986. However, the salary and other benefits paid to the petitioner after fixation with effect from 1/7/1986 is not on account of any fraud of misrepresentation on the part of the petitioner. If there is any error or mistake committed by the respondents, they may rectify the same but cannot recover the alleged excess amount already paid to the petitioner, since the same has already been consumed in catering to the need of himself and his family members. The mistake, if any, was committed by respondents on their own, and in these circumstances after such a long time, and that too after his retirement, no recovery of the amount already paid can be made, though the rectification in respect to fixation can always be done. It has further been contended that in any case, no order adverse to the interest of the petitioner could be passed without affording any opportunity, and thereof the impugned order is in utter violation of principles of natural justice. In our view, once learned counsel for the petitioner could not show that the salary and other benefits which were paid to him could be sustained having sanction of law under any rules or regulations applicable to the petitioner. In the circumstances, it cannot be said that salary and other benefits paid to the petitioner were being paid rightly, and the same could not have been corrected or rectified by the respondents by passing an appropriate order. If there is any error or mistake committed by the respondents in fixation of pay or payment of salary to its employees, such mistake can always be rectified, and principle of estoppel or waiver etc. shall not apply in such cases. Similarly, in such a case, even the principle of natural justice shall not be attracted where the facts and legal position is not disputed. The action or order of the authority cannot be said to be illegal for mere non-compliance of principles of natural justice. But where simultaneously it is found that an employee has been given certain monetary benefits or salary by the employer on its own or by its own mistake, and for which the employee is not responsible or has not played any fraud or misrepresentation, the amount paid in excess on account of such lapse or mistake or employer should not be recovered from the employee, particularly after a long time. It is worthy to notice that relief, that is, restraining recovery of excess amount, is granted by courts not because of any right in the employee but in equity, in exercise of judicial discretion, to relieve the employee from the hardship that he would suffer if recovery is implemented. Per contra, learned AGA submitted that if the law enjoins filing of written objection prior to consideration of bail of a convict accused, then it also enjoins grant of time while considering interim bail. Learned AGA further submitted that if a thing is required to be done in a particular manner, then either it should be done in that manner or not at all. He further submitted that amendment was brought by the legislature so that convicts of death sentence, life imprisonment, or for a term of 10 years or more may not be released on bail easily without hearing public prosecutor. Learned AGA therefore submitted that no interim bail should be granted to the appellant without giving opportunity to the State Council to file objection. On merits, learned AGA argued that conviction of the appellants is sustainable and trial court rightly held them guilty. He supported impugned judgment of conviction and sentence by contending that diary of the deceased indicate that she was maltreated with disrespect. He further submitted on the strength that mother did not support prosecution version as she was compelled for it to save Kedan Prasad from conviction, who was her relative. He further pointed out that PW 4, 5, and 6 have supported prosecution story and therefore evidence of PW 3 does not damage prosecution case, and for this he pointed out page 19. Ultimately, it was argued that bail of the appellants be refused. Now, analyzing ambit and scope of the proviso attached to section 389 of the code, it transpires that the said proviso relates to only to a procedure and does not affect or curtail power of the appellate court in matter of grant of bail. It nowhere restricts or creates an embargo on such a power. What it provides is only a procedure to be observed while considering bail of a convicted accused sentenced with death, life imprisonment, or imprisonment for 10 years or more. Thus, the legislative intent was never to curtail power of appellate court in matters of grant of bail, but only to hear public prosecutor. Scope of such a proviso therefore cannot be stretched to scuttle power of the court to grant interim bail. It was rightly argued that a proviso may carve out an exception but cannot curtail limits of parent section. Further sentences of less than 10 years of imprisonment is beyond the purview of said proviso, where its observance of granting time to the public prosecutor to file written objection can be eschewed, albeit hearing of public prosecutor may be strictly adhered to. Thus, the proviso has been added as an abundant caution only, otherwise, normally, but for certain aberrations, no bail in appeal against conviction is considered without hearing public prosecutor. Mandatory character of granting time to file written objection and hearing public prosecutor has been enacted only to eschew aberrations and block loopholes of hearing state counsel in matters of grant of bail after conviction.